Welcome to today's Explainer. We are jumping right into a totally fascinating constitutional court case today. It's one of those classic unstoppable force meets immovable object scenarios. On one side, you have the strict zero-compromise rules of the private security industry. On the other, the protected rights of some of the most vulnerable people in society, refugees. This tension plays out all over the world, but today, we're looking at how it all boiled down to one incredibly specific, high-stakes legal battle in South Africa.
So here is the core conflict. Can a recognized refugee lawfully work as a private security guard? Now, you might be thinking, well, that sounds like a simple yes or no question. But actually, when you take the profound human desperation of a refugee who just wants to survive, and you put it right up against a nation's absolute demand for public safety, the reality gets unbelievably complicated. The stakes for both sides here literally couldn't be higher.
To figure this out, here's our roadmap. We're going to cover 1. The refugee employment dilemma, 2. Regulating private security, 3. Testing for unfair discrimination, 4. The majority versus the dissent, and 5. The final verdict.
Let's get right into Section 1, the refugee employment dilemma, looking at fleeing danger versus finding work. To really grasp this clash, we have to be super clear on our starting point. A refugee is fundamentally vulnerable. They can't return home, and they are legally very different from an ordinary immigrant or a permanent resident. These are folks who often had to flee violence in a huge hurry, leaving behind their careers, their families, basically everything they own. So when they arrive in a new host country, they are essentially starting from absolute zero. They don't have a financial safety net, right? So for a refugee, finding a job isn't about climbing some corporate ladder. It's literally an urgent necessity for daily survival.
And this is what creates a massive legal paradox. On one hand, the Refugees Act explicitly says a refugee is entitled to seek employment. It makes sense. If a country grants someone asylum, they have to be allowed to feed themselves. But then, on the other hand, the Security Act draws a hard, unforgiving line. It says, flat out, to register as a security service provider, you absolutely must be a citizen or have permanent resident status. Boom. 2 ironclad pieces of legislation crashing right into each other, leaving real human lives caught right in the middle of the gray area.
Which brings us to Section 2, regulating private security, and the absolute need for trustworthy guards. Think about what security guards actually do. They wear uniforms, they bear arms, they guard our property. Because of that, applicants have to provide clean clearance certificates, proving they haven't committed major crimes, like treason, murder, or robbery, in the past 10 years. And to put the scale of this into perspective, it's a massive industry. We're talking about the guards at your grocery store, the people monitoring the bank, the armed crews moving cash through the city. In South Africa, the private security sector employs more people than the national police and defense forces combined. It's huge. So it's absolutely crucial for the government to thoroughly vet every single person in this industry. Security personnel get access to our homes, to giant malls, to restricted areas. They carry authority. And yeah, they often carry deadly weapons. Like the court said, if standards drop, the hazards to the public are considerable, indeed life-threatening. That strict citizenship rule was designed for a very practical reason. It's just objectively easier for a state to verify the criminal history of someone who has a long, documented paper trail in that specific country.
All right, Section 3, testing for unfair discrimination using the Harkson v. Lane framework. Does banning refugees from this massive job market violate the Constitution's guarantee of equality? To figure that out, the court used the Harkson v. Lane test. This is basically the gold standard in South African law for equality cases. It asks 3 questions. 1. Does the law treat people differently? 2. Is that difference actually discrimination? And 3. If it is discrimination, is it fundamentally unfair? Steps 1 and 2. Super easy for the court. Yes, the law differentiates, and they even assumed it discriminates, simply because refugees are an explicitly vulnerable group. Any law targeting them sets off immediate constitutional alarm bells. So, step 3, the fairness question, became the real battleground. Everyone agreed the law blocked refugees, but the giant debate was, is this block a completely rational, necessary safety measure, or is it a cruel, unconstitutional barrier stacked against people who are already marginalized? That takes us to Section 4, the majority versus the dissent, and their split decision. The Constitutional Court was deeply divided here. The majority took a very pragmatic approach. They said, look, the state has a duty to verify trustworthiness. And realistically, it's just easier to check the records of citizens and permanent residents. You can't exactly pick up the phone, call the authorities of a war-torn country a refugee just escaped from, and politely ask for a verified police check. The majority stressed this isn't about prejudice, it's just the logistics of doing a reliable background check. Plus, they pointed out, refugees aren't banned from working entirely, just from this one highly sensitive sector. But on the flip side, the dissenting judges saw it in a completely different light. They argued this blanket ban is unconstitutional because it severely harms a traumatized group without actually being tailored to real security risks. They focused on the devastating human toll. Their argument was that locking refugees out of such a massive source of entry-level jobs risks pushing them into the shadows, making them destitute, and feeling xenophobia. For the dissent, stripping away the ability to earn a living was a direct violation of international human dignity conventions. So what happened? The majority ultimately upheld the law. But, and this is a really big but, they only did so because of a built-in legal loophole, Section 23(6). This part of the law allows the authority to exempt an applicant if they can show good cause. It's a vital piece of the puzzle. It means the law isn't a totally impenetrable wall. A refugee could say, hey, I just want to be an unarmed car guard in a parking lot. I'm not asking to carry an automatic rifle for a cash-in-transit van. Because this flexible exemption existed to handle that exact kind of nuance, the majority ruled the overall law was fair.
Finally, Section 5, the final verdict. Let's see how the court resolved this impasse in the real world. The verdict came down to this. The law itself stands. On paper, it's fine. But the bureaucracy, completely broken. The court found that the regulatory authority was failing entirely to help refugees use that critical exemption loophole. They were literally just rubber stamping refugee applications as rejected. They weren't telling them about the good cause exemption, and they weren't giving them forms or guidance. So a constitutional law was basically being enforced in a deeply unconstitutional, unfair way. To fix it, the court ordered the authority to actually do its job properly and sympathetically. No more automatic rejections. The message was crystal clear. You can't treat a refugee like just any other temporary visitor. You have to recognize their unique legal status, evaluate the actual risk level of the specific job they want, and make a fair, individualized decision. It's all about providing a real pathway to dignity. So I'm going to leave you with this final thought to ponder today. How should a nation balance its internal security with its international human rights obligations? It is a profound tension, and it's one we see playing out not just in private security, but in border control, digital surveillance, and pretty much every aspect of modern democracy. Thanks for joining me on this explainer, and keep asking the tough questions.